Weiss+Associates presents CP508C, the IRS effort to take away your U.S. passport. Do you travel internationally, live in a foreign country, or use a U.S. passport for identification? Those who do use a U.S. passport understand the importance of this document. The right to travel is a critical element with a U.S. passport. So, you arrive at the airport for an international flight, and you present your U.S. passport for clearance to catch the flight to Paris or wherever, and you're told your U.S. passport's been denied and you can't depart the U.S. If you've ever had an experience similar to this, you recognize the immediacy of the problem. And it's going to happen more and more with this latest attempt by the national government to forcibly mandate that certain American nationals pay to fly when they're confronted with a seriously delinquent tax debt by those checking your U.S. passport. For some, you may find yourself confused and dismayed, and you may have no idea what to do. You ask, what's happened to cause this? The answer is basically that you formally became a tax prisoner in your own country and are forbidden to leave. This can be a severe shock to many who still believe the U.S. is the land of the free and the home of the brave. With the passage of the FAST Act by the U.S. Congress, the IRS can send a notice to the U.S. State Department to cause them to deny or revoke the use of an existing U.S. passport or to block your application for a renewal. What would your life look like if you didn't have a U.S. passport to travel due to the IRS claims of your having a seriously deficient tax debt? What can you do at that moment? You're denied the ability to travel internationally for business, vacations, or even return to your home in a foreign country. Slavery kept those enslaved on the plantation. Slavery and involuntary indentured financial servitude was supposed to have been abolished in the Constitutional Republic with the 13th Amendment. Embarrassing? You bet. Probably an understatement. Ticked off? More than likely. You quickly realize that you're not well-versed in federal tax laws and jurisdiction. Immediate attention is required if this ever happens to you. The tax system in the U.S. is geared to controlling the American people, and it's coming to light more each year. Governments who act in this fashion are fearful of losing control over the people. In America, the government should fear the people in order for there to be liberty and justice for all. Unfortunately, Americans have not been good stewards of their inheritance and cannot even provide in conversation any real aspects of the Constitution and the amendments. Today, there is more fear of government in the minds of Americans about what the government might do to them. Fear of government allows them an invitation to control your income stream, banking, and place limits on your ability to travel. At some point, you have to ask yourself, is this what I expect from my servant government? This matter of blocking your right to travel originated from the U.S. Congress in the FAST Act. This bill relates to fixing America's surface transportation. A rider was quietly placed within the legislation related to Subtitle A of the Internal Revenue Code. We suggest that you also view our YouTube video on the birth and death of the IRC of 1954 to better understand that Subtitle A ended on the day it was enacted. Our video on jurisdiction will help you understand that there are two United States, and most Americans have no idea that two actually exist. Some American nationals have been caught by surprise on this latest bit of chicanery by the national government. As mentioned, it all started at the end of the Obama administration, in which a rider bill was inserted into the 491 pages that make up the Congressional FAST Act, or Fixing America's Surface Transportation Act. This add-on has nothing to do with fixing America's surface transportation, but it was a useful tool to hide this from the eyes of the American people before it was passed. Section 32101 of the FAST Act relates to Subtitle A of the Federal Income Tax Code, also known as the IRC, or Title 26, that was originally enacted as the Internal Revenue Code of 1954. If you've received a CP508C certification, the IRS is officially making you aware that they are claiming you to have a tax debt that is viewed by them to be seriously deficient. Once this document is sent to the U.S. State Department, they will not renew your old passport or issue you a new one. Remember, this FAST Act, via Section 32101 for Subtitle A, relates to the federal income tax laws published in the IRC. A seriously delinquent tax debt is defined under Subtitle F, Section 7345, Revocation or Denial of Passport in case of certain tax delinquencies. It relates to 1. An unpaid, legally enforceable federal tax debt exceeding $50,000. 2. The IRS must have filed a notice of federal tax lien under IRC Section 6320, found in Subtitle F. Or 3. The IRS must have filed a levy under IRC Section 6331A, also found in Subtitle F of the IRC. Here's what the IRC states regarding levy authority at Section 6331A. Notice who is listed that can be levied and the employer listed that enforcement action can be addressed to. If any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the Secretary to collect such tax and such further sum as shall be sufficient to cover the expenses of the levy by levy upon all property and rights to property, except such property as is exempt under Section 6334, belonging to such person or on which there is a lien provided in this chapter for the payment of such tax. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the United States or the District of Columbia, by serving notice of levy on the employer as defined in Section 3401D of such officer, employee, or elected official. It's interesting to note that this statute subsection 6331A has made no reference to anyone other than those who work for the national government. Thus, the only employer referenced is the national government. The statutory term person in this 6331A substatute is defined at IRC Section 7701A1 to mean an individual, a trust, estate, partnership, association, company, or corporation. The statutory term individual is defined at 5 U.S.C. Section 552A, A2 to mean one who is a U.S. citizen or resident alien. The statutory term U.S. citizen is defined most clearly at 3C Amdr 2D, Section 2689, who is born in the United States and subject to United States jurisdiction, as follows. A person is born subject to the jurisdiction of the United States for purposes of acquiring citizenship at birth, if his or her birth occurs in territory over which the United States is sovereign. Did you notice the word person again? Now you know who it's referencing, and it's not American nationals. The expression United States is defined in the IRC at Section 7408D to mean only the District of Columbia. In January 2018, the IRS began to attack American nationals who they claim to be U.S. taxpayers. Most American nationals, meaning those born in the constitutional republic or naturalized therein, have never recognized that they work in the private sector with no nexus to the national government. They've not realized that the federal income tax was only levied upon the national government and upon those American nationals who hold a public office established by the U.S. Congress. So, American nationals have no federal income tax liability if they are not identified under any of the 7 criteria for those who are listed by the IRC as being U.S. taxpayers. There are 7 basic types of U.S. taxpayers today. That list comprises the following. 1. Federal employees, federal officers, elected federal officials working for the national government or the municipality of the District of Columbia. 2. Statutory U.S. persons. 3. U.S. resident aliens admitted under a green card to work in the U.S. 4. Statutory U.S. citizens. 5. Those who derive income from the use of federal property such as treasury bonds and T-bills. 6. Non-resident aliens who live in any of the U.S. territories such as the U.S. Virgin Islands, Puerto Rico, or American Samoa. And 7. Non-resident aliens who made a voluntary election to be taxed as a U.S. resident alien, which imposes the national government with the obligation to provide full disclosure of the ramifications of such a voluntary election. Such election must be made with willful and knowing intent as a result of full disclosure. At this moment, you might be asking yourself, what's a non-resident alien individual? The purported definition is found at IRC section 7701B1B and is stated to mean an individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States. We have a narrative on our website homepage about Are You a Non-Resident Alien? We also provide our educational services for American nationals with another YouTube video on what is a non-resident alien. Based on the wording used by the U.S. Congress, can you clearly state what a non-resident alien actually is, or just what a non-resident alien is not? You can only ascertain what a non-resident alien is not. A U.S. citizen is clearly defined at 3C Amjur 2D Section 2689 to be one born in territory belonging to the U.S. government. The now 50 states of the Union, the Constitutional Republic, cannot be classified as territory belonging to the U.S. government. If you still need to study more about this in detail, please review our other YouTube videos, and in particular, the one on Are You a U.S. Citizen? The importance of jurisdiction becomes a real topic of discussion in this matter. Without the publication of an implementing regulation, the FAST Act has no application within the Constitutional Republic and is thus void ab initio. However, the denial or cancellation of a U.S. passport can lawfully be directed at statutory U.S. citizens. As an example, those born in Puerto Rico are a form of U.S. citizen and would obtain a U.S. passport to travel internationally. They are, by birth in a U.S. territory, statutory U.S. citizens, are U.S. taxpayers, and are not protected by the Constitution or Bill of Rights. They are in many respects property of the U.S. Congress, in stark contrast to those born in a sovereign state like, say, Iowa or Texas. So, it's critical to know this distinction, and it's crystal clear the national government intends to advance their offensive and attempt to gain more control over people's lives. It's up to you, and only you, to stop this intrusion, as we now see that sovereign American nationals are now receiving CP508C letters. This is where we at Weiss+Associates can help you pass this barrier that is now in your face and has limited your mobility. Now there's hope to resolve this matter by getting the CP508C reversed. The first step is to learn more about the CP508C and to ask in writing that your U.S. senators and House of Representative member for the district you live in provide you with the implementing regulation for the FAST Act. You must ask for a clean, clear, legible copy of the actual implementing regulation, along with the volume, date, and page number of its publication in the Federal Register. The next step is to learn what a seriously delinquent tax debt actually means and who is identified as being a U.S. taxpayer. Tax liability is simplistically stated by the Federal Retirement Thrift Investment Board document entitled Tax Treatment of Thrift Savings Plan Payments to Non-Resident Aliens and Their Beneficiaries. Admittedly, this publication is several years old, but it's nonetheless a federal document that was presented accurately to those participants. On page 2 of this federal document, you'll find stated, 1. A resident alien participant will be liable for U.S. income tax. 2. A non-resident alien participant who work for the national government in the United States may be liable for U.S. income tax. 3. A non-resident alien participant who never worked for the U.S. government in the United States will not be liable for U.S. income tax. And 4. A non-resident alien beneficiary of a non-resident alien participant will not be liable for U.S. income tax if the participant never worked for the U.S. government in the United States. You just reviewed the fact that the CP508C pertains to a legally enforceable tax debt and that the IRS must be able to use a Notice of Federal Tax Lien or Levy statute within the IRC to make the claim of it being enforceable. All enforcement statutes are promulgated in Subtitle F, which went into effect on the day after the date of enactment of the IRC of 1954. However, that day never arrived, as the IRC of 1954 began and ended on the same day. The question needs to be asked of your elected congressional officials as to the actual publication in the Federal Register via volume, date, and page number of the implementing regulation that's been promulgated in the Federal Register as required of the national government via the Federal Register Act. Due to the inclusion of the Subtitle A, Section 32101, at the time of this video creation, no evidence of such publication in the Federal Register has been provided by the national government. The IRS creates a certification against a legal U.S. taxpayer, referred to as a CP508C, and then promptly sends this to the U.S. State Department to restrict renewal of a U.S. passport or to cause the State Department to refuse to issue a new U.S. passport for first-time applicants needing that important document for the right to travel. If you're a legal U.S. taxpayer, this is a very real problem, and you should make certain that the IRS has your most recent mailing address, or else you might be surprised after your arrival at the airport right before your vacation or business trip abroad. Being a legal U.S. taxpayer means that you have an obligation to file and pay. For American nationals, not subject to the territorial jurisdiction of the national government, the opposite is absolutely true. You have no such obligation. The reason lies in the fact that you're a lawful non-taxpayer as declared by a federal court. The revenue laws are a code or system and regulation of tax assessment and collection. They relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. With them, Congress does not assume to deal, and they are neither of the subject nor of the object of the revenue laws. We've created a motion to address this issue with the U.S. Tax Court on your behalf. There's no need to hire an attorney or travel to Washington, D.C. either. You simply mail our document to the U.S. Tax Court Chief Judge, and the process will result in a court order of dismissal for lack of jurisdiction and the ordering of the IRS to issue a reversal certification, a CP508R. Our history in dealing successfully with the U.S. Tax Court in achieving a dismissal for lack of jurisdiction ensures the success of this effort in defeating the denial or revocation of your U.S. passport. The information we provide is based on federal laws, and they are there for you to take advantage of, as have our multitude of clients. Education is vital, but so is action. Be proactive now before things become too unbearable and more frustrating. We have resources such as ways to bank internationally while bypassing the FATCA problems. You can learn about other countries that offer a relaxing and more stress-free environment to live in or retire in, how to protect your assets, and how to make them more portable as you relocate. We have assisted many clients with a variety of services that we don't mention even on our website. Only our clients have access to that information. Now is the time to be proactive as things are rapidly changing in the U.S., and you need to strongly consider the path to freedom with our revocation of election process. At Weiss+Associates, we're apolitical. We just recognize the skillful mastery of politicians who seek to gain control over the lives of the people they're hired to serve under. We're privacy advocates and believe in less government interaction in the lives of American nationals. The U.S. Constitution is the hope for all American nationals to stay free, but without the education and proper application of the law, the future of the U.S. does not bode well. It's drifting rapidly toward socialism, which history has proven over and over again to simply not work. You should be preparing for a major event around 2020 for the implementation of the Real ID Act on a national level. The state driver's license will become part of or be replaced by a federalized database of all driver's licenses issued throughout the 50 states. Your right to travel may be impacted drastically if you don't accept the new driver's license with a chip implanted in it. You may not even be permitted to fly domestically any longer without your chip-implanted driver's license. There will be facial recognition and lots of your history embedded into that chip for starters. Initially, you'll still be permitted to drive anywhere in the U.S. without being part of the federal database, but the question remains, for how long? If you think you're fearful of the U.S. government now, just wait a decade from now when you'll be stopped at regular intervals and demanded to provide a proper response to "Your identification documents, please." You'll really know what pressure is and that your freedom is completely lost. And if history has taught us any lessons, the government will not stop at this level, but eventually It will have a complete record of your history from birth, educational history, evaluations by the schools you attended, law enforcement violations from minor to serious ones, family members, addresses where you live or have lived, and so on. It will no doubt be expanded at some point in time to encompass DNA information and other biometric parameters to further document who you are and track your every move. Most American nationals will comply simply out of fear of their government. There's been no serious outcry against the TSA intimidation under the claim of protection and safety. Many Americans will use the tired statement, "I have nothing to hide, so what's the issue?" A small percentage will be outraged and start looking for a new place to call their home country. Coincidentally, Americans who are seeking the protection from the border wall in the southern portion of the Constitutional Republic need to be thinking also that the wall is not just useful to stop the flow of problems from Mexico, if that's possible, but that it'll also become a potential barrier for Americans who might wish to someday leave the U.S. Personally, we hope that our forecast is overstated and exaggerated, but with the past you can, from having hindsight of history, see past today and plan better for tomorrow. Be prepared and think critically. Our goal is to assist approximately 500,000 American nationals with securing privacy and a path out of the darkness and fear of government. At that point, we'll have achieved the objective we set out to accomplish. We at Weiss+Associates offer you the option to take advantage of our services now. Be proactive and don't delay. It starts with our revocation of election process, which lawfully removes you from the U.S. tax club. More information on this can be found clicking the links in the show notes below. You can email us at bilateral@gmx.com. If you found this video informative, please give us a thumbs up and subscribe to our channel. Thanks for watching.